Hello, everyone. This is Tom Fox, the voice of compliance, and I'm thrilled to introduce a new podcast series I've been wanting to do for some time with my good friend, Jonathan Marks. So, Jonathan, please introduce yourself to the audience.
Thanks, Tom. It's an honor and a privilege to be here today. Like Tom said, my name is Jonathan Marks, and I'm a partner at Baker Tilly. I lead our global forensic investigations, compliance, and integrity services practice. I've been dabbling in fraud and forensics for about 35 years now, so hopefully one day I get it right.
Well, I love working with you, junior people. We are here to talk about the role and evolution of the role of boards of directors in compliance. And I thought, Jonathan, we could really start at the beginning, and that is the original Caremark decision, which happened in was released in 1996, and then follow that up with the Stone and Ritter decision, which upheld Caremark 10 years later in 2006. And one of the things that struck me in researching those cases for this podcast, Jonathan, is either nothing is ever new, or everything old is new again, or back to the future, because the facts of these cases were so basic in terms of both, in the case of Caremark corruption, in the case of Stone and Ritter, as basic a fraud as you can get. And here, in the case of Caremark, nearly 30 years later, in the case of Stone and Ritter, 20 years later, you're probably getting calls on the phone saying, could you help us with this? And you're shaking your head, yes, I can help you with that. And so it was really interesting for me to see the schemes and scams employees will pull really continue to this day. And it really struck me with Caremark, because the Caremark case involved a medical services company, Caremark, which provided medical services to patients and pharmaceutical products to patients. And they would get referrals from doctors, or rather make referrals. And then Caremark would sell their services or products. Then the doctors would bill, and Caremark would receive the money for that. And where Caremark got into trouble, and when I say trouble, I mean some pretty significant trouble, was they were basically bribing doctors to refer their products. And the ways they were bribing them, Jonathan, were in many ways some of the same examples we see in FCPA, FCA, and other cases right now. They were paying doctors for research papers that never occurred. They were paying doctors for speeches and training that never occurred. They were taking doctors and their wives out for lavish dinners. They were funding renovations of doctors' offices. And when I wrote about this case, I just thought, how FCPA-ish can you get? Yet this was 1996. And I guess before we get to the role of the board, I'm always intrigued by what you see from your internal auditor hat. So in looking at those sort of background facts, are you just going to say, Tom, this sort of scheme and scam has been going since 1666, not 1996? Or is this something new and different that bribery and fraud scams evolve, and you have to be ready for that as an internal auditor?
I think as long as we have humans in the loop, we have to be ready for anything at this point. This probably goes way back beyond Caremark with regards to the duty of loyalty that somebody has with regards to their organization, and what they're going to do, with regards to, making sure that there's proper oversight and monitoring, related to not only the issues that are in front of them, but also the issues related to what we now know as compliance and complying with laws and regulations. It wasn't too long ago where compliance really wasn't really spoken about separately. It's only relatively a new concept. And if we turn back the clock, maybe 20 years, it was the same thing with internal audit. So, I think compliance is going through sort of this growth that we've seen because of the importance that's been laid upon its feet with regards to making sure that ethic, you know, ethical behavior is something that's not just talked about, but it's something that makes up the fundamental backbone of an organization.
Jonathan, I mentioned that the actions of Caremark were viewed very seriously by the U.S. government. They were hit with a 47-page indictment for violations of something called the ARPL law, the anti-referral payments law, which prohibited healthcare providers from paying any form of remuneration to physicians to induce them to refer Medicare or Medicaid patients. And the costs were quite dramatic for 1996. There was 164.4 million fine and penalty, and then there was an additional 98.5 million settlement with payment providers who were defrauded by Caremark's Act. So nearly 262 million in fines and penalties. And this was 1996 when, a million was real money. So Caremark got into serious trouble with that. I should have mentioned the Stone and Ritter facts because I didn't want to laugh when I read this, but it seemed to me about as basic a fraud as you can get. You had some investment advisors who either decided or created some high interest investments. They got 40 or 50 people to invest, allegedly on the basis of 20% yields. And they paid a few of those yields until, of course, the money ran out and their Ponzi scheme dried up and they couldn't get more investors. But this was not a case against the investment advisors, but AmSouth Bank, because the investment advisors set up a custodial account to pay the investors. And they were routinely paid for about 12 months until the money ran out, at which point they started contacting the bank because the bank was releasing the funds. And that's when it all unraveled. The bank was sued, or charges were brought against the bank, rather, for number one, failure to perform due diligence on the two fraudulent investment advisors. And number two, more importantly, under the Bank Secrecy Act, which was strengthened after 9/11 in the form of the Patriot Act, the settlement with the bank was just beautifully lawyerly written. It said, quote, at least one, end quote, employee thought a suspicious activity report should have been filed. So it seems to me that probably it was pretty clear an SAR needed to be filed, and it wasn't. And so the bank could have identified this fraudulent scheme to investors. And here I wanted to ask, have you ever worked on one of these schemes where someone promised high rates of return and it was either a Ponzi scheme or some other scheme? This one seems to me about as old as we've had coined money.
Yeah, and I've been working on these types of cases for years, and they seem to manifest themselves in different ways as time moves on, but the general schemes generally remain the same. So the answer to that question is yes.
So we had as basic a fraud scheme as we could have in Stone versus Ritter, and shareholders, the Stones, sued the chairman of the board, who was named Ritter. That's how we get to Stone v. Ritter. And they sued that the board should have taken steps to determine this Ponzi scheme and then stopped it. And so those were the facts on this case. And then we turn to the court's holdings. And here is where I thought it got really interesting, because I didn't quite realize, Jonathan, what a big change Caremark was. The prior Delaware case on board's obligation was called Alice Chalmers, well-known manufacturing firm. And there, the court held that absent actual knowledge, a board did not have to called it spying on its own employees through any mechanism, whether that be internal controls, whether it be internal audit, whether it be compliance, although compliance didn't exist in 1963, or whether it be through corporate legal. So there was no duty on a board, affirmative duty, unless someone brought actual knowledge to them. And that was thrown out on its ear by the Caremark decision. And the Caremark court pointed to three reasons for the change. And I found these really interesting. One was the increased professionalism of boards of directors between 1963 and 1996. 1963 was the date of the Allis-Chalmers decision, and 1966 Caremark. Number two was boards had increased duties in the mergers and acquisitions sphere. And the increased duties required them to do more than simply rubber stamp corporate senior management when they tried to do deals. I don't know if you worked in deals in the 80s, but in the heyday of green mail, boards literally just rubber stamped whatever management wanted to do, whether that was Boone Pickens in Texas or, Ivan Boesky or somebody in between. And the third was something near and dear to our hearts, the 1992 U.S. Sentencing Guidelines. And the Delaware court pointed to this as evidence that the federal government was putting boards on notice that they had to be involved, and that they thought that was one more reason for the change in the law. So we had change in the law, and Caremark really led that because boards needed to now have a duty to exercise appropriate attention in two contexts. One is to avoid negligence, and the second is to arise from the failure to act in circumstances where, quote, due attention, end quote, would have prevented the loss. This was the first time we saw the board have an affirmative duty, and the court called it due attention. So that's sort of the change in legal. And I was wondering kind of what your thoughts are about that evolution as well.
Well, it's kind of interesting. I mean, you talk about the U.S. federal sentencing guidelines. I think we're coming up on, what is it, 20th anniversary or 30th anniversary?
30.
Been around 30th anniversary, right? And I think there was just a study that was actually released, I think last week or the week before. But if you take a look at the fundamental 7 components we refer to it as Chapter 8. I don't know if you guys, the lawyers, refer to it as Chapter 8, but standards and procedures that obviously protect and detect criminal conduct. You could go on and read the rest of them yourself, but I think that the key things here are, as these things started to manifest themselves, these fundamentals have really made their way into other models around not only building out what I'll call an effective compliance and ethics program and the 11 hallmarks that exist today, but there's definitely overlap there. But if you look at the laws and around the globe, like for example, if you look at Law 231 in Italy, those laws are modeled after the U.S. federal sentencing guidelines as well, with regards to what constitutes an effective compliance program and the like. So it's kind of interesting to me how this is all coming to pass. I'm not a conspiracy theorist, although you might think I am. And we've talked about this ad nauseum over the years, but there have been certain events that have taken place. The U.S. federal sentencing guidelines being released, Sarbanes-Oxley, all these other things. I think these are sort of these warning shots across the bow that provide organizations and companies the opportunity to clean themselves up. And we've seen what a mess this all can be without proper oversight and without boards that have a duty of loyalty or lack independence or don't have the wherewithal to really understand what the issues are from an organizational perspective. So it's, I kind of sit back and take a deep breath and I look at what's going on today, and I just wonder how, had people actually paid attention and did the simple blocking and tackling, whether you and I would even be sitting here today talking about this. And the answer is probably still yes, because I think we live in a world where everybody always wants to take the shortcut and they don't believe that having an effective compliance program is really necessary until they get caught. And that's not saying that this applies to everybody, but it would seem to me, based on what I've seen over the specifically last 10 years, that there is we just don't learn our lesson. And it's amazing to me. We all talk about and read the enforcement releases. We all talk about things that don't even make the enforcement releases. We talk amongst ourselves about issues that we're seeing with our clients, in an anonymized way, but they just seem not to, it just doesn't seem to be getting any better. And I just don't know why. maybe you know why, but I think when you take a look at Caremark and you take a look at some of the other cases that have happened over the years, Disney, and then recently, the Bluebell ice cream case, and Boeing, and some of the other things that really have these instances or trickles of duty of care and duty of loyalty, with regards to the boards. I wonder when we're actually going to wake up. I mean, I go to these training sessions and I sit in, or I go to these conferences and I sit in, and I start listening and hearing some of the things that are being taught. And, I just wonder whether we should just go back to the fundamentals. Like, do you really know what a duty of loyalty is? I asked that question, much like I asked the question around, can someone give me a definition of internal controls? Until this very day, nobody ever gives me a great answer on what an internal control is. I wonder if you asked, 1,000 board members, what constitutes a duty of loyalty, I'd be hard pressed that many of them could give you. I'm sure they could talk their way around it, but I'm just wondering whether they really understand what that actually means.
Well, that is a great way for me to think about why Caremark was so significant. And Caremark you're absolutely right. It is one of those inflection points because prior to Caremark, the duty of loyalty did not have the obligation to look, to put a system in place to look, to put a compliance program in place, to put a system in internal controls to look. Caremark did not say boards of directors have to go down and individually audit salesmen to see their expense account spending. It didn't say they have to be decamped into a legal or compliance office looking at GTE expends for conflicts of interest. They said they have to put an appropriate board level program in place, or ignoring a program that exists. And then the beauty or the significance of Stone versus Ritter is it really defined those as a part of the duty of loyalty. And Jonathan, I'm going to read these because I want to go back to these when we talk about later cases. Bluebell is going to be one, Boeing's going to be one, but the Stone and Ritter court further refined the Caremark doctrine with two conditions for director liability, and they were: number one, directors utterly failed to implement any reporting or information systems or control, completely turning a blind eye. And we still have cases like that, or we did within the past 10 years. But number two is if they have implemented such a system or internal controls, consciously failing to monitor or oversee its operations, thus disabling themselves from being informed on risks or problems requiring their attention. Now, we're going to see particularly that second prong really does, I think, get expanded, and we may be watching the growth or the parameters of the Caremark doctrine expand. But those two prongs are as stark a statements as you can have about what the board's liability is now and why boards need to actively engage in oversight. Interestingly, in both the Caremark case and the Stone and Ritter case, the plaintiffs were not successful. So it took a long time for the Delaware court to uphold a Caremark claim. But you're absolutely right. Not only are the facts patterns still relevant today, are people still relevant today, but these articulated standards are just as relevant today. And when you put on your training for boards, I hope that, well, let me just ask you, do they know what their obligations are? Not even getting to the question of can they define a duty of loyalty, but when you ask that question in board training, do people understand at least the word oversight?
I think they do today. I don't think they did 3 years ago, but I think they do today. I think they've heard it enough. But, again, it's, you could say one thing and, you could say all the right things, but whether you actually take that and put it to action, we all know that sometimes we all talk about paper programs and compliance. When I sit there and I look at boards and, and we talk about issues, and we talk about what it really means to have a duty of loyalty or a duty of care. And sometimes people say all the right things, and I just wonder whether those actually transcend themselves into real actions, or it's just noise coming out. And you really don't know until you get down into the nitty-gritty. Um, I always listen to what they have to say. I'm respectful of that, but I have my own way of getting to the truth, and that is, I start to ask further questions. The greatest thing about understanding what root is you don't stop at the first why. You keep going until you think you got the right answer. So I do the same thing with training, because I'm not doing this to embarrass anyone. I want to do this. When we train boards and we advise boards on certain things, we do it because we want them to be better. We want them to understand what their obligations are to their stakeholders. We don't want them to be in a situation or any type of litigation that certainly stems from or involves around their lack of a duty of care, or anything even remotely related to that. So if I could walk out of there and make one board member understand how critical this is, and you could turn that in, and that individual has at least some form of influence over everybody else, I'm hopeful that this concept that we call disremember risk is really not 90%, but it's something that reverberates itself enough where people actually do remember what their obligations are. But I'm still not 100% convinced. Again, there's a lot of training that goes on, Tom, as you well know. You can go out today and everyone's talking about this, a big deal. It's a big risk. Everyone's talking about ESG. I'm not even going to talk about that today. Everyone's talking about this. How about the fundamentals of being a board member? How about the fact that you have to do the work? How about the fact that, this duty of care involves a duty of oversight? And oversight doesn't mean asking a question and getting a response. Oversight means, asking a question, getting a response, and then fundamentally looking at the context of that response, and then looking at the evidence. And if it doesn't make sense, you keep pushing and you keep asking, because again, that's what the stakeholders are expecting of you. And I just don't, forgive me, and I know some people are going to listen to this and say, well, I do this, I do this, I do this. Do you really? Ask yourself that question. Do you really spend time understanding what the issues are? Do you really spend time in that oversight capacity? The days when we talk about nose in, fingers off, and all that kind of good stuff, that's fine. You should never step in the shoes of management. But that doesn't mean that you shouldn't ask the tough questions. It doesn't mean that you shouldn't ask to see, what was done. It doesn't mean that you shouldn't cleverly find out if management is doing what they say they're doing. And sad to say, most of the folks that I talk to, they get it, I think, to some point, but I think at some point I still see that there's a huge void there for whatever reason that is. And maybe it's, Warren Buffett said it best one time. He said, when the tide rolls out, you see who's swimming naked. We talk about sticking your head in the sand like an ostrich. When this whole concept of enterprise risk management came out, nobody wanted to do it. And the reason that nobody wanted to do it, I'm utterly convinced of this, is they were afraid what they were going to find out. They were afraid that the risks that they identified weren't really the risks that actually impacted the board. And so I think that a lot of times board members just don't ask the tough questions because they never want to be asked a question, well, did you know? And we all know it's not only did you know, but should you have known? And so they try to protect themselves. And I still think that a lot of that exists today. Say what you want. You have to do your own self-assessment of yourself if you sit on a board of directors, but you fundamentally someday at some point something's going to go bad, and you have to be willing to be able to answer the question, did I know? No. Why didn't I know? Did I not know because I was afraid to ask the question, or I asked the question and somebody didn't tell me the truth? That's a different situation.
Well, Jonathan, unfortunately, we're near the end of our time for this episode, but that's a great way for this to end our episode. I'm greatly looking forward to doing this series with you, and look forward to next time.
Always fun, Tom. And, like I said, if one person, can influence somebody else, especially at the board level, so that duty of care and that duty of loyalty really does mean something, then I think we're doing our jobs.